Case on this morning's docket is case number 103881, State of Kansas v. Crawford.
May it please the court, my name is Dan Monette. I represent the appellant in this case, Kenneth Crawford. I would respectfully request the reservation of 2 minutes rebuttal time, Chief Justice.
2 minutes is granted.
And if the court desires, I can do a quick factual summary of the case.
We've lost most of our audience. I hope you don't take that personally. Whatever you're comfortable with, counsel.
I'm fine to proceed on. The prosecution's burden of proof beyond a reasonable doubt in this aggravated kidnapping, aggravated indecent liberties, criminal threat case was something like a jigsaw puzzle with some of the pieces missing. So explained the Assistant Attorney General at both the beginning of this trial in jury selection and at the end of this trial in his closing argument. The Court of Appeals held that at least those actions were misconduct, but not such conduct as to be harmful enough to result in the reversal of Mr. Crawford's convictions or 28-year sentence. This court granted review limited to the issue of misconduct. Today, we ask this court to reverse Mr. Crawford's convictions and remand the case for a new trial. During jury selection and closing argument, the Assistant Attorney General explained that proof beyond a reasonable doubt was like a seascape jigsaw puzzle with some of the pieces missing. At least 7 times, the prosecutor referred to a jigsaw puzzle with some of the pieces or some pieces or pieces missing. The prosecutor's explanation created the risk that the jury may find Mr. Crawford guilty even if some of the pieces missing from the evidence were elements of the crime or facts necessary to establish those elements. Thus, the Kansas Court of Appeals correctly recognized the explanation as misconduct because the language used by the prosecutor in the words of the Court of Appeals, quote, implied to the jury that it could find Crawford guilty even if some of the evidence was missing if it looked like he committed the crimes, end quote. As this court made clear in the Mitchell case, for 129 years before this Crawford case went to trial, this court consistently stated, quote, no definition or explanation can make any clearer what is meant by the words reasonable doubt than that which is imparted by the words themselves. And in the Magallanes case, this case summarized, before this case came to trial, all the kinds of explanations that could not be given to a jury. So in fact, it had to have been abundantly clear to this prosecutor when the case went to trial that the pieces missing explanation of proof beyond a reasonable doubt was misconduct. What happened to Mr. Crawford here is exactly what the court recently found especially troubling in the Stevenson case, namely the potential for quantifying reasonable doubt by discussing the difference between missing one letter as compared to more. Quantification occurred in the Crawford case. The Assistant Attorney General here didn't talk about missing 1 or 2 pieces of the puzzle. He talked repeatedly about multiple pieces of the puzzle missing. And unlike Stevenson, this analogy was not just limited to voir dire. It was raised in jury selection and closing argument, and essentially the prosecutor asked the jury to view constitutional due process proof beyond a reasonable doubt through a distorted lens or a distorted structure from beginning to the end of the trial.
Mr. Monette, address the third prong of harmlessness for me on this. That's where I'm stuck. I think we have abundant case law on not quantifying, not describing, not redefining reasonable doubt. So I don't think your hurdle here is the existence of error. I think your hurdle is the evidence and the weight of that evidence. So where are the weaknesses here that should persuade us that this made a difference?
Well, the Court of Appeals in this case simply held that the jigsaw puzzle explanation had likely had little weight in the minds of the jurors, but that sort of implies it could have had some weight. This court in Champath-Singh, I think, clarified that third prong of the second prong of the Tosh test by saying, quote, "The state, as the party who has benefited from the prosecutorial misconduct, bears the burden to show that there is no reasonable possibility that the error affected the defendant's substantial rights, i.e., that there was no reasonable possibility the error affected the verdict." The Court of Appeals didn't make that finding. They made one that applied the opposite. As discussed in our brief, this was not a case that had evidence that was direct or overwhelming. SV described a timeline of events that conflicted with law enforcement's independent investigation of the timeline about when Mr. Crawford's truck left the shop. The state presented little physical evidence to place Mr. Crawford's truck at the alleged scene and no physical evidence to place SV inside Mr. Crawford's truck, despite many efforts to do that.
What about the DNA and I'm sorry, I didn't mean to interrupt.
That's okay.
What about the DNA under the fingernails? And since and I guess I'm looking at that pretty closely because he didn't testify, and so there's really no explanation as to how the scratches got there. There's no explanation as to how his DNA got under her fingernails, other than the fact that she's telling the truth.
He did explain how some of the scratches got on him from working under the truck with the baling wire that was hanging down from holding pieces together. And as for the DNA evidence, at the most, it just showed that SV came into contact with Mr. Crawford's DNA at some time, in some place, in some manner. It did not necessarily corroborate the particulars of her claim that Mr. Crawford deceived her and tricked her into going out into the country with him and did not confirm that he molested or threatened her. The evidence showed that Mr. Crawford was an occasional and recent visit to the home of SV and her mother. The DNA evidence shouldn't be considered for more than it is, and Justice Biles, what you suggested a minute ago, that Mr. Crawford didn't testify, his statements were in the evidence over and over that he steadfastly and repeatedly denied the accusations of SV, despite the law enforcement officers even trying to give him false evidence to induce him to admit the same. Here, I think we cannot be said that there is no reasonable possibility that the prosecution's misconduct affected the verdict. Also remember, the jury sent back a question implying that it even questioned some of SV's credibility. It sent back a question asking, for criminal threat, do we have to have a verbal threat, when the only threat SV had ever testified about was a verbal threat, but the jury wondered if it could be non-verbal. So I think that the explanation of proof beyond a reasonable doubt here as a jigsaw puzzle is gross and flagrant and ill will because it ignores 129 years of law, but also because this wasn't like Stevenson. This was ill will and flagrancy because the prosecutor had a long-range, premeditated plan from front to finish of the case to get away with long established misconduct. And what he gave the jury in the beginning was something that distorted their view of the facts throughout the entire case. When you couple that with, I'm sorry, Judge.
Now, Stevenson was the Wheel of Fortune, right?
Yes, Your Honor.
I'm having a little trouble distinguishing missing letters versus missing pieces of the puzzle.
Well, as Justice Luker pointed out, in the Stevenson case, it scuffed the line of misconduct there, but she emphasized that they never tried to argue that there was anything missing more than one letter of that. Here, we're not talking about one or two. We're talking about the prosecutor arguing that he could meet the standard of proof beyond a reasonable doubt, even when multiple pieces of evidence were missing. And that also creates the risk that multiple elements are missing if, to the jury, in the words of the prosecutor, it just looked like Mr. Crawford was guilty. So I respectfully submit that those kinds of distinctions and the premeditated nature of the opening and closing use of the jigsaw puzzle, coupled with the prosecutor's misconduct by telling the jurors, contrary to long-standing Rule 169 in voir dire, I'm going to guarantee that I'm going to want to talk to you about this case by the time the case is over, and we'll talk when the case is over, that kind of misconduct from beginning to end of the case, along with the far from direct and overwhelming evidence here, is exactly what made this harmful error in this case and requires reversal of Mr. Crawford's convictions. A couple points I wanted to make right at the end here is the Court of Appeals seemed to think that because a sufficiency of the evidence claim had not been raised here, that somehow that was a concession on the prong of harmful error. We asked this court to strongly discourage that kind of finding, because misconduct to show harm and insufficiency of the evidence are two completely different animals. And I don't think this court wants to go so far as saying we always need to raise a sufficiency of the evidence claim in order to preserve a misconduct claim is harmful. Also, some of the cases cited by the state say that this jigsaw puzzle analogy is not prejudicial error or not harmful error. A lot of those cases, however, rely on the fact that the jurors were read the instruction on reasonable doubt and received the instruction on reasonable doubt. I just want to point out here that, regrettably, the court somewhat itself belittled its instructions by, before it read the instructions to the jury, reciting that a silly rule required His Honor to read those instructions to the jury, even though they were perfectly able to read them themselves. That minimized, in some sense, the heft that the usual instructions would have. For all of these reasons, we ask Your Honors to reverse the convictions in this case. Thank you very much.
Do we have any questions of counsel? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Chris Elslager, appearing on behalf of the state. I think when you look at what the prosecutor was saying here, it's pretty clear. He was not defining reasonable doubt beyond the words themselves. He was not trying to attach a quantifiable measure to reasonable doubt. He was simply trying to illustrate the concept in a way that the jurors could relate to and understand. And I think it's very similar to what occurred in Stevenson, which was released after this. Yes, Your Honor.
Distinguish for me an explanation and an illustration.
Well, he didn't go into definitions of what these words mean. He's saying, here's a concept, here's a picture of how it could be applied. It's more of a conceptual application rather than a hard definition of this is what reasonable doubt means, this is the quantity that you have to find. He didn't do that. And this is very similar to Stevenson.
I don't find that persuasive. To draw a visual picture to try to explain the concept, how is that different than using words to describe the concept?
Well, the court has, I think there's a lot of case law that said it's okay for lawyers to use analogies to illustrate concepts in a way that jurors can relate to.
We've said that frequently, but we've also said forever, don't try to explain reasonable doubt.
And I said,
How much more clear can we be on this point? I mean, it's very frustrating. It really is.
It's frustrating for me too. I've stood here several times on this same issue, and I think that there's a definition, as in the dictionary definition, and then there's what is this? How is this concept kind of applied in a sense that everybody can relate to? And that's what Stevenson, the attorney, was doing in Stevenson with the Wheel of Fortune. That's what the attorney here was trying to do. And the point is, what they're always getting at is not trying to define reasonable doubt, but to draw a distinction between what beyond a reasonable doubt is and beyond all doubt. That beyond a reasonable doubt is not beyond all doubt.
Why can't
they
you just
just
say
say
that?
that?
Say that.
Why can't we just say that? I mean, I'm frankly surprised, Mr. Arslooker, to hear you today say this was an error, as opposed to fighting your harmlessness battle.
Well, and the reason is because Stevenson came out after this case was decided. And quite honestly, Stevenson said it wasn't error to use that Wheel of Fortune analogy. And to me, the Wheel of Fortune analogy was a closer call because there it was almost quantifiable. You had one letter missing, and you had a visual aid there. Here, the prosecutor just said, just imagine in your mind a jigsaw puzzle. You all know what a jigsaw puzzle is. There's some pieces missing. You can still tell what it is, though, because there's enough there to see it. That's what it's not beyond all doubt. It's just beyond a reasonable doubt. And when you look at what he said in closing, he came back to that point. He said, he referred back to the jigsaw puzzle and he says, there's always going to be pieces of the puzzle missing because none of us were there. None of us were at the crime scene to see it. So his point was, it's not beyond all doubt. And so and the only reason I argue is because now we've had the Stevenson cases has come out.
That explains it to me. Why don't you address harmlessness?
Well, I think that first off, it's not gross and flagrant because
Even though it's repeated, it starts the trial that way, ends the trial that way?
Again, the case law says that you can use analogies. And he's just trying to illustrate beyond...
The case law says you can use analogies, but not on reasonable doubt.
Well, you can't try to, if you look at the case law, it says you can't try to quantify reasonable doubt. You can't use easily recognizable symbols. You know, you look at the case law, there was one case where they used the picture of Abraham Lincoln. Everybody would know what that looked like. Another one was the Statue of Liberty, and within a couple of pieces of the puzzle, anybody could tell what that was. So that's one extreme. The other is a lot of the cases they used visual aids where they would start filling in pieces of the puzzle until there was like one piece or two pieces missing. The court said, no, that could be construed as quantifying. Other cases, the prosecution said something like, well, you can be 95% sure or something along those lines. That's quantifying. The prosecutor here wasn't trying to quantify. He thought he was within the parameters of the case law by saying, by leaving it open. There's just some pieces missing. We can't show you everything because we can't possibly collect every possible piece of evidence to lock this up. This isn't a TV show. This isn't, it's not beyond all doubt. None of us were there, so there's always going to be a piece of evidence missing. We didn't see it. That's what he was getting at. And when you look at the case law, I don't think you can say that's gross and flagrant because he wasn't defining reasonable doubt. And when you look at his closing, what he was really doing was talking about, how you look at the credibility and the evidence of the credibility of the witnesses. Because he starts out saying you get to determine the credibility of the witnesses and think back to the jigsaw puzzle. He says there's always going to be missing pieces because none of us were there. And then he talks about are the questions you have reasonable and so on. And I think that in itself is probably not particularly problematic. He didn't mention the term reasonable doubt or anything. He just said that he just acknowledged there's some pieces of the evidence missing. There's pieces of the story that are missing. but none of us were there, so that's why. And I think that's actually pretty common in all closing arguments, because I mean we never have all of the evidence. I mean rarely can we prove a case beyond all doubt. Excuse me. Now, and it's also interesting that none of his comments ever drew an objection. So I mean clearly, I know that doesn't matter for issue preservation, but the defense counsel didn't think that he said anything objectionable. The trial judge.
You can't do that, because defense counsel all the time have to make a strategic decision whether to object and draw attention to something, and you cannot say that the defense lawyer didn't find it objectionable. Because if I'm sitting there as the defense counsel, I don't know what to do with this. I don't even know what this means. Well, I hear the prosecutor say, I got some missing pieces out here. And I'm trying to figure out whether the statements that are made by the prosecutor aren't capable of being interpreted by jurors as applying a higher degree of certainty than is required here. Sort of like the Miller versus State case that we just had a couple months ago, where the each and any, and does that communicate an inappropriately higher degree of certainty? And so I don't know what this means. So if I'm defense counsel, I don't know what I'm going to do. But you cannot say that the defense lawyer didn't find it objectionable.
Well, I agree with you, but the point being is that when you get to the point of gross and flagrant, I think if the prosecutor is doing something that is gross and flagrant, something that is that bad, that the defense counsel would say something. Now, if he's just, if it's not something that's that big of a deal, then he's probably not going to object. But we're talking about gross and flagrant error. We're talking about error that is obvious, that clearly violates existing case law. And I've seen plenty of objections in closing arguments. So that's why I illustrate that. I'm not saying that the defense counsel was necessarily happy with it. I see your point there, but I think it's just a factor to consider. Okay, that's all. I'm not saying that's it. That's the mop that wipes away the wipes away everything. I mean, that's just a factor to consider when you're analyzing whether it's a gross and flagrant violation. Does that make sense? I mean, I'm not saying that's the King's X.
I do think we need to move on to the strength of the case from the evidence.
Certainly. I mean, number one, the victim provided eyewitness evidence. I mean, that's the first thing. You've got the eyewitness testimony.
Counsel, I would characterize that as direct evidence.
That is
Didn't you? Okay.
Yeah.
Your opposing counsel made the comment that it wasn't direct and overwhelming evidence, and I understand his point on overwhelming, but I didn't understand the point on direct. But if you have an eyewitness, that's direct evidence.
Yes, Your Honor. That is, so you had direct evidence there. She testified subject to cross-examination. And he had injuries on him that were consistent with her story. He had the scratches on the side of his face and on his side. And his DNA was under her fingernails. It's pretty strong evidence. He gave some inconsistent stories about when law enforcement spoke with him and interrogated him. And there was some circumstantial evidence that corroborated the victim's story. There were the tire tracks in the field, the oil spot in the middle of the field. His truck leaked oil in about the same spot. And this little girl was found out in the middle of nowhere. I mean, she didn't walk out there on her own. So I think when you add up the direct evidence, the DNA evidence, and the circumstantial evidence, it's a pretty strong case, and I think the Court of Appeals got that right. And if there are no further questions, I will close there and ask the Court to...
Which piece of that puzzle you just mentioned would have swung it the other way?
I'm not following your question.
There was evidence that inculpated, but there was exculpatory also, wasn't there? That with the timeline and that sort of thing. And I'm just saying, if it didn't make any difference, when you start adding up all of these things that make it overwhelming, I'm asking which piece of that would have swung it the other way.
And I would say that I can't quantify that because it's not a quantity of evidence. It's a totality of the evidence.
And that's the problem.
But there are some pieces of the evidence missing. I mean, we weren't there. We don't have a videotape.
Yeah. Okay,
so the videotape's missing. We don't have a video of the crime. We don't have like the TV show, the CSI expert there that that can put it all together and connect all the dots for us. Those TV pieces are missing, but we still have enough evidence to prove beyond a reasonable doubt that this is the guy that did it. If there are no further questions.
One thing that struck me as I read the briefs was how many other states have dealt with this question on the jigsaw puzzle and have said it was error. Does that weigh into our factor of considering gross and flagrant?
Well, certainly it does. I mean, it can. But I would also point out that they're not uniform, that it's error. Virtually none of them found it was reversible error. Some found it wasn't error, so it's mixed. And if you look at the cases where they found it was error, there's a couple distinguishing features. One is the use of the visual aid, the PowerPoint slide that shows pieces of the puzzle, so there's a quantifiable amount. There was no quantifiable amount here. And there was no visual aid. It was left in the juror's mind. The other thing is the use of easily recognizable things like the Statue of Liberty and the picture of, I think, Abraham Lincoln, that kind of thing. Those are distinguishing features. But in virtually none of those cases do they find reversible error. And so I would say the case law is not, it's not consistent. I think there's only one case that, if I'm recalling it right, one case that found reversible error, a lot that said, hey, this is problematic, but we're not going to reverse. And there's a couple of cases that said, no, it's just an analogy, it's okay.
But my thought is, why would a prosecutor use something like this when there's case law out there saying, don't do it? That's very, exactly with the jigsaw analogy.
Well, again, though, there's no case law on point in Kansas. There's no controlling case law. And the case law is, it's not consistent across the country. And I think, I remember when I argued Stevenson, I think it was Justice Rosen maybe that said, look, this kind of thing happens all the time in trials. The prosecution wants to point out to the jury that it is not beyond all doubt, and the defense wants to convince the jury that it is a lot closer to beyond all doubt, and that these kinds of things happen all the time. And apparently that is the case, because a lot of these cases come up. And I would just submit to you that the case law is not clear, and that's why the prosecutor thought he was okay here. Again, no Kansas case law directly on point. We've said they can use analogies. He didn't think he was defining reasonable doubt, and when you look at the case law from the other jurisdictions, it really is inconsistent across the spectrum. There are cases where they said it was, some states have said it's not error, and I would just leave it at that. Could you address the factor of ill will in our calculus? I don't think you spoke on that. Well, honestly, there's nothing in the record to indicate ill will, and usually, I think it's hard to define ill will. You're looking at a cold record, but the most obvious indication is when the defense objects or the court admonishes a prosecutor to stop doing something and he keeps doing it, or he tries another way to get around it, and that didn't happen here. And when you look at it, it was really just a single time in his closing arguments. What he said was, you get to determine credibility of witnesses. And when I talked in voir dire about the jigsaw puzzle and the scene with the lighthouse and the ocean, there are always going to be pieces of the puzzle missing because none of us were there. None of you were there. The question you got to ask yourself is, just because a piece of the puzzle or pieces of the puzzle are missing, does that mean you can't see the whole picture? Are those questions reasonable in your mind? Think about motive. What kind of 12-year-old would come up with this? So he's going on, what he's really doing is telling the jury, look, assess the evidence I presented to you. I know I can't present the entire picture because none of us were there. We don't have a videotape of it. There are pieces missing, but consider whether or not those rise to the level of reasonable doubt. I don't think that shows any kind of ill will. It's clear he's trying to make a reasonable argument. There's no objection, and it's not like the defense counsel objects, hey, I think you're going over the line, and he tried to rephrase it and get back to his point. That didn't happen. He wasn't admonished by the court and continue. And I still stand by, I don't think there is clear case law that would just make it obvious that he was wrong. So I think you would be really hard-pressed to find from that record ill will.
Well, opposing counsel has pointed out that this started in jury selection, and it was also done in closing argument, and I think he made the point that this therefore showed that this was planned. And I'm just asking whether that is something we should consider in determining whether there is ill will. Well, no, certainly it's planned. You can't argue that it wasn't planned, but it wasn't. Every step of the trial is planned, but you got to look at what was the prosecutor's intent. Did he believe he was within parameters? And certainly he did.
I think what he did in voir dire was just like Stevenson and would not be misconduct. He was just trying to draw the distinction between the concept of proof beyond all doubt and proof beyond a reasonable doubt, so he could select the jurors that understood it's not proof beyond all doubt. And then he just referenced it back in closing to say, look, I know I haven't given you every single piece of the evidence, but that's because none of us were there. So assess the credibility, assess the evidence. And yeah, certainly it was planned, but it was not planned with some kind of diabolical intention to railroad this innocent man into prison. It was planned because the prosecutor believed that this was allowable under the case law, and that all he was doing was just drawing a distinction between the concept of beyond all doubt and beyond a reasonable doubt, and then trying to apply that to the evidence.
All right, thank you. Do we have any further questions of counsel?
Thank
Thank you,
you.
Counsel.
Simply ask that you affirm the Court of Appeals. Thank you.
You had reserved 2 minutes for rebuttal.
Thank you, Your Honor. First of all, I believe that ill will can be shown by indifference to long-standing rules. And as I think the whole panel has recognized, it's been a long-standing rule for 129 years that you can't define or explain proof beyond a reasonable doubt any more than the words carry. The prosecutor here wasn't talking about one or two pieces missing. The prosecutor was talking about multiple pieces missing, and thereby, unlike Stevenson, the prosecutor quantified beyond a reasonable doubt in a distorted way. And here, the prosecutor wasn't explaining in voir dire the difference between all doubt and all reasonable doubt. If you look at the context of what he was saying in voir dire, first, the last thing he was talking about before that was whether the defendant had to testify, and the next thing he was talking about after that was who had medical problems and might have to be released to accommodate them from jury service. The pieces of the puzzle and the suggestion that if it looked like the whole picture but there were some pieces missing always is going to create the problem of whether the jury brings back a verdict without finding each and every element of the crimes beyond a reasonable doubt. From what this prosecutor told them, they could find one or two elements missing and say, well, the prosecutor told us that proof beyond a reasonable doubt was just like a jigsaw puzzle with some missing pieces, so it really doesn't make any difference that we don't find that Mr. Crawford committed all of those elements beyond a reasonable doubt. The ill will here is clear. The gross inflagrancy is clear. The misconduct is clear. This was not an open and shut case. It cannot be said there was no possibility that this affected the jury's verdict. Accordingly, I would ask your honors to reverse Mr. Crawford's convictions. Thank you, your honors.
Thank you. Do we have any more questions of counsel? Thank you. We thank you both for your arguments this morning. Court will take this matter under advisement.